So welcome everyone to Stu Clark webinar, All Things Legal for Startups. A friendly reminder, this webinar will be recorded and posted to our YouTube channel, so no need to take notes. You'll be able to reference this at any point later on, and it'll be automatically emailed to you. So today we are going to talk about all things legal for startup. And before we get started, I'm just going to go over a little bit of Zoom etiquette. First of all, welcome, and we'd love to hear from you in the chat. Introduce yourself. We had a couple people do so already. We will handle questions in the Q&A portion of the webinar at the end of the presentation. So toss those questions in the Q&A function on in that little chat bar at the bottom, and we'll make sure that we get to all of them. And don't be afraid, any question is welcomed, and we have a really good lineup that is ready to tackle those questions, so don't be shy. And before we get started, I just want to show a quick video about the Stu Clark Center for Entrepreneurship and what we do there. So sit back and take a look at this video.
Let's talk about entrepreneurship. It's the light bulb moment from your first big idea. It's the decision to set out on a new path. It's the realization that entrepreneurship starts with a spark, and that spark starts here. At the Stu Clark Center, we're here to nurture your ideas and help spark your entrepreneurial spirit. How? How about competitive opportunities to free your inner entrepreneur? Advice from venture coaches who have walked the walk, or some of the best networking events you'll find on campus. You'll find it all right here. By focusing on education, awareness, community, coaching, and connection, we build strong relationships with our students and do everything we can to help them on their journey to self-starting. At the Stu Clark Center, we thrive when you thrive. No idea is too big or too small. The Stu Clark Center is your one-stop shop for everything you need to start your journey. So why not start today?
All right. So that is what we do at the Stu Clark Center for Entrepreneurship. And if any of you are familiar with the Drake Center, we are located on the main floor of Drake in room 212, right by one of the set of entrance doors. So you come by, swing by. We want to hear from you. We'd love to meet you. And don't be afraid to just stop in and find out what we're up to, because we're always up to some fun things. So I'll just quickly introduce the team at the Stu Clark Center. We have Deborah Johnson-Young, our director, myself, Lindsay Friesen, marketing coordinator, our program coordinator, Amy Jones, and then Melinda Sasick, our office administrator. So we are a small but mighty team, and we have a lot of fun at the Stu Clark Center. And so really just want to say, come stop by and say hi at any time. We'd love to talk with you about your entrepreneurial idea. So with that too, you are obviously here today to learn about all things legal for startups, but we do have a number of other upcoming webinars to put on your calendar and on your radar. Please feel free to sign up to any of them. They're all free. Most of them are recorded unless we have a guest speaker, and you can register for them at umanitoba.ca/entrepreneurs. And we have one of our team members will toss that link in the chat for you. So go take a peek there, and you can sign up for any other webinars that pique your interest. Another note on that, we do have an extensive online library of webinars that we've been doing for the past 2 years. They have a variety of topics that are very helpful to the everyday entrepreneur. So go check that out. And again, they're all on our YouTube channel and also on our website. So lots of cool things for you to go check out. So with that, we are all here to talk about all things legal for startups. And I would first like to do a little shout out to Yvonne LaRock and Nick Solonsky, because they are the ones that have made this collaboration come to life. They are supervising lawyers and instructors at the Kerry Vickar Law Clinic, and they have voluntold 3 of their wonderful third-year law students to present today. And so with that, I will introduce our presenters, and they're going to pop their video on so we can see their face. We have with us Austin Sutherland, Robert Johnstone, Scott Grote, and they are third-year law students with a very keen understanding of law and have put together a special presentation for the everyday entrepreneur and some things to keep in mind, to consider, and to plan for. So with that, I'm going to stop sharing and hand it over to them. And just one final note, all those questions you have for them while they're presenting, toss those in the Q&A, and we will get to all of them at the end with the Q&A portion. So with that, welcome Robert, Austin, Scott, and I will let you take it from here.
Thank you, Lindsay. We are truly excited to be here today, and hopefully we can all learn something new. As previously mentioned, my name is Robert Johnstone, and let's jump into all things legal for startups. Firstly, this presentation is for information only and does not constitute legal advice or create a solicitor-client relationship. If you have a legal issue, you should seek a lawyer. We make no guarantees regarding the accuracy or adequacy of the information contained herein or linked to this presentation. So just to introduce us, the Kerry Vickar Business Law Clinic consists of 22 third-year law students and makes up the largest business law clinic in Canada. Throughout the school year, we immerse ourselves in all facets of business law under the guidance of experienced lawyers. Special shout out to Yvonne Larocque and Nick Sanonsky for all their hard work. Further, since winter of 2022, we've contributed over 5,000 hours of pro bono services to the Manitoba community. So here's a picture that encapsulates all 22 members of our team. Each student is a member of the Law Society of Manitoba as a student at law, as well as the Manitoba and Canadian Bar Associations. What do? Well, through the clinic, we provide free legal assistance to entrepreneurs. Yes, you heard me correct, free. Small businesses, startups, innovators, charities, and artists who do not have a lawyer and cannot afford legal assistance. In particular, our services include providing information and advice to clients on forming business entities, drafting legal documents, and conducting legal research on issues such as regulatory compliance, good governance, stakeholder activism, and social responsibility, amongst other things. So if you're curious or want more information about us, you can visit our website, where we try to provide a lot of useful information to our clients and website visitors. The clinic also serves a diverse array of clientele, including 50% women and 37% from BIPOC. Geographically, we serve clients from all across Manitoba. Statistically, this is broken down to 73% Winnipeg, 9% Eastern region, 11% Central, which includes the Interlake, and 7% other. So in terms of a roadmap for today, I'm going to be starting with business organizations and some of their legal consequences. Then, Austin Sutherland will be covering incorporating a business and the nuances of contractual agreements. And then lastly, Scott Grote will get into intellectual property and some of its issues. If you have any questions, please save them until the end. Questions should be general in nature, and try to avoid sharing specific details about your own legal issue. In the event we aren't able to answer your question, we'll defer to our supervising lawyers or find an answer and get back to you. So to start with an overview, as of June 2022, there are about 1.33 million businesses with employees in Canada. Out of those, 1.3 million were small businesses, almost 23,000 were medium-sized businesses, and just around 3,000 were large businesses. In particular, Manitoba had 43,000 businesses with employees, with over almost 98% of those businesses classifying as a small business. So as you can see, small businesses are very prominent in both Canada's and Manitoba's business landscape. And here's a picture of our website where if you go to the website, this is what you'll see. This is also what you'd see prior to filling out a client intake form for the clinic. So many of you are going to be familiar with business, so this isn't all going to be brand new, but I will go over the legal ramifications for each business form. starting with sole proprietorships. A sole proprietorship is basically an individual carrying on business. Further, they're informal in nature, so anyone is able to start a sole proprietorship. There isn't any citizenship or residency requirements. You may still need to register a trade or operating name, and I'll get into that here. So if you're a sole proprietor operating a business under your legal name, for example, as Robert Johnstone, you generally do not need to register the business name, but there are exceptions where registration is needed. If you want to use a name other than your legal name, you will need to register it. This applies to circumstances where you are a sole proprietor but are adding something to your legal name that modifies it. For example, if my business name is Robert Johnstone's Pool Boy Services, then I need to register it. It's important to mention that if you don't register a name that you are using, it can result in significant fines and other legal consequences. Sole proprietorships are also subject to unlimited personal liability. So, say I ruin a customer's pool liner while I'm cleaning the pool, they could sue me, and I could be personally liable for the damages incurred. Next, for structures, we're going to go over partnerships. Partnerships have at least two individuals or entities carrying on business. Both people and businesses can enter into a partnership, and it's important for partners to have a partnership agreement, which governs the relationship between the parties. While partnership agreements are not a requirement per se, they are important to help outline the responsibilities and protect the interests of each partner. For example, if there's no partnership agreement, the law provides a partnership is dissolved upon the death, insolvency, or bankruptcy of any of the partners, or if there is a dispute that can't be resolved. Partnerships can range in complexity depending on whether you have a partnership agreement or not, and the terms and details contained in the partnership agreement. So all partnerships should have a business name registered with the Manitoba Companies Office, but there aren't any residency or immigration status requirements for having a general partnership. There are exceptions to this, but there are usually exceptions in law generally. When registering a business name, you are required to list a business address. You can list an address outside of Manitoba, but that constitutes a statement that the business has no physical address in Manitoba. If the business has a physical address in Manitoba, the Manitoba address must be listed. This is just an important note. Generally, partners and partnerships are exposed to unlimited personal liability, which can be subject to limitation depending on the type of partnership it is. Partners can be joint and severally liable, which means that each partner can be responsible for the debts and obligations stemming from the partnership, both together and separately. So, say if someone sues the business for something, the partnership, they can go after one partner, some of the partners, or all the partners to recover their damages. If one partner in the partnership makes a mistake, the other partner or partners will be on the hook for that financially. That's just the structure. There are also special kinds of partnerships, such as limited partnerships, where liability can be limited. In limited partnerships, one of the partners, called the general partner, accepts unlimited liability, and this allows the other partners to limit their liability. Moving on to corporations. Corporations are formed through the process of incorporation, which creates a distinct legal identity. Austin will also discuss this for his section on incorporation. Generally, corporations are more complex than both sole proprietorships and partnerships. There's costs involved. The costs for starting and maintaining a corporation are more significant than those for sole proprietorships and partnerships. There are also more documents involved, and requirements such as holding annual meetings, maintaining share records, keeping minute books, and filing an annual return with the company's office. They receive different tax treatment from other business forms. So corporations are required to file annual corporate tax returns with the CRA, and small businesses can benefit from tax deferral and low corporate tax rates. They can be publicly or privately owned, and I'll expand on the structure of a corporation and the concept of legal personhood and the protection of liability in the following slides. So there are three main groups of people in a corporation. There's the shareholders. Shareholders are the ones who own the shares of the corporation. Most corporations have different classes of shares, each of which has different rights. Shareholders sometimes vote on important corporate decisions, such as electing directors. but they are generally not involved in the day-to-day operations of the corporation itself. Next, we have directors. Directors are in charge of the overarching goals of the corporation. They decide on the long-term vision of the corp and select officers to carry out the day-to-day operations. There's also a requirement that at least 25% of a corporation's directors must be residents of Canada. This is both a federal and provincial requirement. Next, we have the management. Management are also known as officers, so you may be familiar with positions such as the CEO, CFO, COO, etc. They basically oversee the day-to-day affairs of the corporation. The exact responsibility of the officers are set out by the directors and by the bylaws, so they can be quite variable. The officers basically work to maximize profit for the shareholders. You can also wear multiple hats in the corporation. What do I mean by that? Well, it is common, especially in smaller businesses, for people to have multiple roles. Each role, whether as a shareholder, director, or officer, comes with distinct rights or responsibilities. So it is important to understand how they apply to you. However, like I said, you can mix and match these roles. There is also fiduciary duty, which applies to directors and officers of a corporation. Fiduciary duty is a concept that every director and officer of a corporation, in exercising their powers and discharging their duties, must, firstly, act honestly and in good faith with a view to the best interests of the corporation, and the general idea that you must put the interests of the corporation before your own. What does this mean? It means that you cannot compete with the corporation of which you are a director or officer. The basic rule is that while acting as a fiduciary, if anything happens where your personal interest or other duties might draw you away from your fiduciary duty, you must avoid the conflict. Directors and officers are also required to exercise their care, diligence, and skill that a reasonably prudent person would exercise in comparable circumstances. There's a bunch of case law on this topic, and it can get quite nuanced and complex, but just to summarize, the role of a director or officer comes with a lot of responsibility. We will talk about separate legal personality next. This is the concept that a corporation is firstly, a separate person from those who own its shares, that being the shareholders. Secondly, separate from those who control its large-scale strategic decisions, that being the directors. And thirdly, from those who manage its operations, the officers. This is the single biggest differentiating characteristic between sole proprietorships, partnerships, and corporations. The Corporations Act, Section 15.1, states that a corporation has the capacity and the rights, powers, and privileges of that of a natural person. This basically means that it is separate from those who own its shares and form its management. Corporations can sue and be sued, own and sell property, enter into contracts, and in the event a corporation is sued, the personal assets of the shareholders are protected. The corporate structure basically limits exposure to liability, and it generally reduces but does not completely eliminate legal risks. However, all transactions carry risks such as default, loss, negligence, breach of contract, and many more. Lawyers are crafty and they can find problems for you. But these issues can be mitigated through limitation of liability clauses in contracts, following laws and regulations, good business practices generally, and insurance. So as you can see, each structure has its quirks, but corporations are generally safest when carrying on business or dealing with large sums of money. So that concludes my part. I hope you have a better idea about the different business structures and some of their legal consequences. Now I will pass it over to Austin to discuss how to actually incorporate your business and work with contracts.
Thank you, Rob. Good afternoon, everyone. Today I'll be talking about the process you need to go through in order to incorporate a for-profit business. It's a relatively easy process and can be completed online. So, how do you incorporate? Before starting the process, you must have a business name reserved, and this can be done online through the company's office. Once you've completed this element, you can move on to the formal steps of incorporation. In total, there are only 11 sections that must be filled in to incorporate a company. First, you must file your articles of incorporation. Provincially, you would do this under the Corporations Act, and the cost is about $350 plus tax. In addition, there's a $45 fee for your business name reservation. If you're incorporating federally, it's a similar process. However, you'll be complying with the Canada Business Corporations Act rather than the Provincial Act, which, as previously mentioned, is the Corporations Act. The cost federally is about $200. Since we're in Manitoba, I'll focus on the process we use here in the province. So up here on the screen, you'll see the information that you should have on hand when going through the process of incorporation. I'll go through these steps in a bit more detail to give you a better idea of what the process looks like. So we'll start with naming the corporation. Corporations are given a numbered identification, and this can be used as the corporation's name. The name is usually a series of numbers followed by Manitoba, and then a legal element like incorporated or limited, for example. If you'd like to give the corporation a different name, you can file a request or a name reservation, and this can be done online through the company's office. As an aside, you can find all relevant forms on their website. Once you've reserved your name, you'll have 90 days to file your articles of incorporation. So that's this document that you see on the screen. When you file your articles of incorporation, the name has to match the name of your corporation. So if you decided to keep the numbered identification as your name, you would use that. But if you reserved a different name, you can use that one as well. But keep in mind that the new incorporated name must still end with a legal entity like incorporated or limited. Again, this can be done online through the company's office website. So next we'll talk about the address of the registered office. So the registered office of your corporation is where you must keep the books and records of your corporation. So that includes things like minute books, bylaws, resolution, articles of incorporation, and other important documents. Most people opt to keep their corporate documents together for the most part. If it's a Manitoba company that you're part of, the registered office has to be in Manitoba. If a lawyer helps you incorporate or is helping you with a business matter, often people will choose to have their business's registered office at the lawyer's firm. Next, we'll talk about the number of directors. On your articles of incorporation, you have to declare at least one director, but if you think you'll want to add directors in the future, you can state a range of numbers. For example, you can say a minimum of 1 director or a maximum of 10. But keep in mind you have to have at least 1 director listed with their full name and address. So, what is the role of a director? Directors of a corporation are responsible for supervising the activities of the corporation and making decisions regarding the future of the corporation. Directors have to be at least 18 years old, non-bankrupt status, and they must be an individual person. So as Rob talked about earlier, a corporation is considered a legal person, but a corporation cannot be a director. At least 25% of your directors have to be Canadian residents. Usually the person who incorporates the company will be a director, but that doesn't always have to be the case. Incorporators have the same criteria as directors, so they must be at least 18, non-bankrupt status, etc. One large difference between an incorporator and a director is that a corporation can incorporate a company, but the corporation cannot act as a director of that company. Next, we have classes of shares. So shares basically represent ownership in a corporation. When someone buys a share of your company, you'll issue them a share certificate. Anyone can be a shareholder. Basically what it does is it represents some sort of ownership in the company. In the Articles of Incorporation, there's a section where it'll indicate how many shares you can issue and the different types or classes of shares. You can give different classes of shares, which may have different restrictions as well. There's no limit to the number of classes of shares that you can put in your Articles of Incorporation. Further, just because you indicate a type of share doesn't mean that you have to actually distribute that kind. So some people indicate a lot more classes and number of shares than they ever think they'll need to distribute, just so they don't need to go back and update their Articles of Incorporation if there's a high potential for growth in their company. However, it is also perfectly okay to keep the number of shares small, and there's always ways to amend your Articles of Incorporation later on. You can have restricted shares or unrestricted shares. Unrestricted shares will give shareholders the right to vote, dividends, and they can receive property upon dissolution of the company, as well as other potential rights. Restricted shares might have restrictions on them. For example, they may only give their shareholders the right to vote, but no dividends, or there might be a restriction on the resale of shares without board approval or shareholder approval. So putting restrictions on shares are a good way to retain some sort of control over your company and where the shares end up eventually. I'll just add in that it is best practice to consult with an accountant on share distribution, as they may be able to assist on a variety of business and tax matters. So the next step is one that we often see forgotten with more inexperienced incorporators, but it's very important to the creation of your company, and that's the organizing of your corporation. You'll see some of the important things that you'll do at your first organizational meeting on the screen. Section 99 of the Corporations Act requires that you hold an organizing meeting with directors. And at this meeting, you make bylaws, adopt forms of security certificates, corporate records, appoint officers, appoint an auditor to hold office. You can make banking arrangement and transact any other business. This doesn't need to be a formal meeting, but all the steps must be completed in order to have your corporation properly formed. So now you've filled out your articles of incorporation and held your organizing meeting, but there's more that you have to do. There are a list of activities that every corporation must undertake each year for the upkeep of your corporation. These include hosting an annual general meeting and filing an annual general return. These processes can also be done online through the company's office website, just like when you're incorporating. This step is also very important for keeping your corporation properly active, even if it's a single person corporation. So I hope this section gave you a better idea of the steps that you have to go through in order to incorporate. And if you're going through this process, we do encourage you to seek legal advice or come to the Kerry Vickar Business Law Clinic for free legal help from the students. And now we will discuss some important elements regarding contracts, including their importance and the different types. I'm sure you've all heard of contracts before, but what exactly is a contract? A contract is a legally binding agreement between two or more parties. For there to be a contract, there must be four things: offer, acceptance, agreement on material issues, and consideration. Firstly, an offer is a promise to do something or not to do something in exchange for certain actions from someone else. This is what we also call performance. So an example of this would be me offering to mow Scott's lawn for $20. Next is acceptance. Acceptance is when someone agrees to perform the requested act in the offer. Back to our example, I offered $20 to mow Scott's lawn, which he has indicated and accepted that offer. That would be acceptance. Agreement on material issues means that all important details are decided upon. For example, a material issue in our example would be whether I am mowing his entire lawn, just the front, or just the back, which can often affect the offering price. This would be a material issue which would need to be decided upon before the contract is binding. Lastly, we have consideration. Consideration is a benefit or gain that each party can expect to receive from the contract, often referred to as the quid pro quo, in that both parties get something out of the arrangement. So Scott would expect to have his lawn cut, while I would expect to receive $20 for performing that service. If I were to offer to mow the lawn for free, this would not be a contract, as I would not be gaining anything from the contract, which is a fundamental element of a binding contract. So contracts are a fundamental part of business because they can ensure tasks that need to be completed will get completed. They can also prevent other conflicts down the line. You might form contracts with business partners, investors, employees, and clients throughout your business endeavors. Next, we will examine the enforceability of contracts. So up on the PowerPoint, we have a few bullet points that I'll go over in turn. So to start off, verbal contracts are actually enforceable. There's a common misconception that verbal contracts are not valid ones, but they can be enforceable, provided that both parties intended to create a legally binding contract. For example, if I went to a garage sale and told Rob, I'm going to give you $20 for this chair, and he accepts the $20 in exchange for the chair, that would be an enforceable contract, even though nothing was written down. Despite verbal contracts being enforceable, certain contracts do have to be in writing. So, for example, a real estate transaction would need to be in writing. If you wanted to buy a house, this would have to be in writing for it to be a valid contract. However, not all written contracts are valid. For example, a contract may be unenforceable if the language in the contract is unclear, the contract was entered into under duress, which means someone is forcing you, or there was a mistake, a misrepresentation, fraud, or incapacity. If these elements are present, then it is possible that the contract is unenforceable. You also do not need a lawyer to make an enforceable contract. It may be helpful to have a lawyer draft something for you, especially if the matter is complex, but it is not necessary. Next, it is also difficult to terminate a contract. So one should be very careful when signing contracts while also ensuring that you review everything thoroughly. Once you enter a contract, you typically cannot end it unless all parties agree or there is a breach of the contract. Further, a contract may be enforceable despite a breach, as there are often methods to remedy the breach, which would require the remainder of the contract to be carried out. If a contract is breached, there are several ways that you can resolve it. Some of these include talking to the other party and giving them the opportunity to resolve any issue, negotiating some sort of settlement, or even a potential lawsuit. I will say that lawsuits are generally a last resort because they take up a lot of time and resources to proceed with. Next, we will talk about some common business contracts that you might encounter. These include non-disclosure agreements, employment agreements, as well as lease agreements. For this seminar, we will be focusing in more on non-disclosure agreements. So, non-disclosure agreements, or an NDA, is a legal contract between parties that restricts the disclosure of information to parties that are not part of the contract. So the purpose is to allow parties to share information with each other without being accessed by outsiders. As an example, if you hire an employee at a restaurant, there might be some kind of secret meal or recipe that this employee has to make, and you don't want other people to know what that recipe is. So you can get that employee to sign an NDA so that they cannot share that recipe with others. This can be helpful for ensuring that your ideas and confidential information aren't stolen or shared. Some examples of confidential information can include customer information, financial information, intellectual property, marketing information, or operating information. If you breach an NDA, you can get sued and potentially have to pay damages. Finally, I'll address the difference between an employee versus an independent contractor. If any of you decide to start a small business, it's important to consider whether you will hire employees to complete work or independent contractors. To begin, an employee typically works for one client or their company. On the other hand, independent contractors may work for many different individuals. An employer has more control over an employee as they have direct control when and how the work will be done. On the other hand, an employer may contract with an independent contractor to complete work. However, the employer has little control when or how the work will be done. Further, the work might not even be completed by the independent contractor, as they may contract the work out to a subcontractor. Further, as an employer, you often have to provide equipment to the employee to complete the work, whereas an independent contractor is often responsible for supplying their own equipment. The nature of the relationship also often varies. Employees are typically in a long-term relationship with an employer, whereas independent contractors may be hired to only complete one task. The pay structure is also different. Often employees are paid by the hour, and however long it takes to complete a job is what the employee will receive. Independent contractors, on the other hand, are compensated depending on the job. They have the opportunity to negotiate a contract for a task, and depending on how the work goes, they may receive a high margin of profit or they may take on a loss.
All right, I'll finish off this seminar talking about different forms of intellectual property. So looking now towards intellectual property, there are many different forms of IP, but for this seminar, we'll be focusing on 4 different types: that of copyright, trademarks, patents, and trade secrets. So the first type, copyrights, are a bundle of rights an owner has in relation to something original that they have created. This would include literacy, artistic, dramatic, or musical works. Just to note here, the image shows that the term for copyright protection is the author's life plus 50 years, but this has been increased to 75 years. Trademarks are a sign that is used to distinguish your goods or services from others. This can be a word, design, or a combination of the both. Patents are the ownerships granted for the exclusive right to make, use, or sell their invention for a limited time. Just to note, the 3 of these are all federally regulated. Lastly, I'll finish with trade secrets and how these differentiate from patents. So trademarks are made for marketplace branding, aimed at preventing consumer confusion and making one's brand recognizable and distinct, consisting of some sort of combination of words, sounds, designs, colors, or textures. Trademarks do not have to be formally registered for them to be recognized, although it is advisable to register them, as they can provide some more protection. With this, you can have it registered Canada-wide. So if you're in Winnipeg and you register your trademark, people in Vancouver can't use your trademark, which can be a great option if you're potentially planning on expanding your business outside of the province. In the event you use a trademark that's already being used by someone else, you may be liable for what's called passing off infringement. Infringing on someone's trademark can result in an injunction filed against you, which means you have to stop using the trademark. It is also possible for you to be sued because of this. So given that there are consequences for using trademarks that aren't yours, you can actually conduct a search of registered trademarks on the Canadian Intellectual Property Office website. So this is a free website to use, and checking the website can help ensure that you're not infringing on someone's right to a trademark. So up on the screen are some examples of trademarks that we should all be quite familiar with. So I can see there are differences between how these were created, in that some of these trademarks have no logo, such as Oreo and Coca-Cola, which just use words. Others have a logo, such as Lululemon, Starbucks, and Mercedes, that just have an image with no text, where some use a combination of the both, such as Red Bull Racing in the bottom left corner. So despite these differences, these trademarks aim to achieve the same objective, the These companies have created a brand and a logo that is easily recognizable and is able to be differentiated from other businesses. Now we'll talk about copyright law. So copyright law looks to protect areas of cultural expression, such as literacy works, artistic, dramatic, or musical works. This is the exclusive legal right to produce, reproduce, publish, or perform an original piece of work. Copyright protections are automatically created at the time of creation and are automatically renewed, and is aimed at preventing direct copying with the term of the author's life plus 75 years. So when you own the copyright work, you control how it is used in order to protect its value. Usually, you cannot use someone else's work without permission. For example, you can't use a recent popular song in a video that you may make, or use an image you found online for a work presentation. Also, you can't copy a work to make your own version, and these rules apply even if you aren't using the work to make a profit. Only the person who has the copyright in a work can give you permission to use it. The person who has copyright can be the person who created the work, but it can also be a business. For example, a company with a bank of photos. Different countries have different copyright laws. In Canada, copyright is governed by Federal Copyrights Act. In Canada, you can register your copyright with Canada's Intellectual Properties Office. It is not a requirement to register your copyright. However, if a copyright work is registered, you will receive a certificate of registration, which can serve as additional evidence that the work truly belongs to the creator. So in the event that somebody infringes on your copyright, you have that support available. As I've stated, the creator of the work is the owner of the copyright unless there's an agreement that says otherwise. So there are ways they can use copywritten work. So to use somebody's copywritten work, the copyright must be transferred through a license or an assignment. A license allows a party to use the work, but the creator still has ownership and the rights associated with that piece of work. So a great example of this is with streaming platforms such as Apple Music or Spotify, which has licensing agreements with artists or record labels in order to use their product. An assignment operates differently in that assignment transfers all or some of the rights to another party for the entire term of the copyright or a specific period of time. So the big difference between licenses and assignments is who owns the rights to that piece of work. As was mentioned earlier, oral agreements are enforceable, but when discussing licenses and assignments in copyright law, they have to be written and registered at the Copyright Office. There are a few exceptions to copyright infringements. So under Section 29 of the Copyright Act, it talks about what is called fair dealing. This allows one to use copyright work for research, private study, education, parody, or satire. If you have a criticism, review, or news report, that can also be considered fair dealing. To be considered fair dealing, certain requirements must be met, such as the following were mentioned. A, the source, and if given the source, the name of the author in the case of work, performer in the case of performer's performance, a maker in the case of sound recordings, or a broadcaster in the case of communication signal. The Copyright Act goes into great detail about exceptions to using copyright material and how it's applied. The second last form we'll talk about of intellectual property will be patents. So patents look to protect works in the science and technology section, specifically regarding inventions, products, or processes. So if you have an invention that you want to protect for a limited time, it may be worth thinking about if you like to register for a patent. So for a patent, you will have to disclose how you created the invention to the public in exchange for a limited time monopoly on that particular product. So if your invention is something that you want to essentially keep secret forever, then a patent might not be worth getting, and you may want to focus more on a non-disclosure agreement as an example. So to get a patent, it can be a difficult process because the guidelines for obtaining one are quite rigorous and very time-consuming. Additionally, these can also be very expensive to obtain, and there are continued costs for having a patent, which are some reasons why you might want to think carefully before applying for one. To note, our clinic does not deal with patents as you must have a registered patent agent to assist in the matter. However, in terms of providing information, we can still probably provide some information about patents, but we just cannot file anything for you. So the last form of intellectual property I'll look over here is trade secrets. So trade secrets means any piece of information, including formula, pattern, compilation, program, method, technique, process, negotiation position or strategy, or really any piece of information contained or embodied in a product, device, or mechanism that is or may be used in a trade or business, is not generally known in that trade or business, has economic value from not being generally known, and is the subject of efforts that are reasonable under the circumstances to maintain its secrecy. So trade secrets are used to do several things, such as ensure an invention or a design is not disclosed to the public before an application for a patent or industrial design has been made, protection of an invention through means other than patent protection, and to protect valuable business information that is not normally protected through other intellectual property rights. So trade secrets can potentially last forever, provided the information actually remains a secret. Once the secret is out, the business value is usually lost and the trade secret protection ends. So there are ways to keep trade secrets secrets. These can include non-disclosure agreements, confidentiality clauses, encryption, password protections, and an actual locking key, such as keeping the piece of information in a safe. So a great example of a trade secret would be the Coca-Cola recipe. So since it has not been patented, it has never been revealed to the public. So other companies will try to replicate that recipe, but no other brands will have the exact same taste. So before we end, I would just like to bring some attention to the Manitoba Legal Clinic for the Arts at Robson Hall. The Manitoba Legal Clinic for the Arts serves artists, creatives, and arts and cultural organizations throughout Manitoba. It is also the only clinic in Manitoba that provides free legal information and services tailored specifically to artists and arts organizations. Being a proud member of the National Network of Legal Clinics for the Arts, the clinic is staffed by students and professors at Robson Hall, the same students and supervising lawyers who are working with the Kerry Vickar Law Clinic. Some common concerns that would arise with the arts clinic could include artists seeking information regarding the rights they have to a piece of work they have created, how they are able to protect their work, and questions concerning contracts. So any type of artist, including craftspeople, musicians, and performers, can fill out an intake form on the clinic's website, just as they are able through the Business Law Clinic's website. So that brings us to the end of our presentation, and we hope that you found the information provided by Rob, Austin, and myself somewhat useful. If you're wondering what your next step is or which direction you should go in, or curious about what you should do next, you can scan these two QR codes up on the screen. So the one on the left will take you to our website, which will refer you to Manitoba and federal resources, depending on the topic you want to explore more. If you're interested in scheduling an appointment and meeting with one of us, you can scan the QR code on the right side of the screen. From there, you can fill in an intake form, which can you find on our website as well. So again, thank you all for listening. And if you have any questions that you'd like to ask Robert, Austin, or myself, we'll try our best to answer them. And if not, you can, of course, always fill in an intake form or come and see any of the students at the Kerry Vickar Business Law Clinic.
Thank you so much, Robert, Austin, Scott. You covered a lot of ground in a short amount of time. Thank you very, very much. We do have two questions in the Q&A, so I'm going to toss it up to the first one we have is, what is different if the trademark is not formally registered versus registered? Someone want to take that on?
So a big difference between those two. If it's formally registered, you have that piece of information. You have yourself to show the other party that this is a registered trademark. Whereas if you don't have it registered, you don't have that evidence to support your claim. If you want to learn more about trademarks and the benefits of having a registered trademark, you're of course more than welcome to come and talk to one of us, and we can provide with more information need be.
Perfect. Thanks, Scott. Another question here we have is, what is the metric used to determine if a proposed brand name or TM is different enough from existing registered ones? Who makes that determination, and is it subjective?
So with trademarks, again, the big concept behind it is preventing customer confusion. So it has to be distinct enough where a client's clientele or a business's clientele would not get confused with another brand's name. So a big case earlier was with Mattel and Barbie, as in Quebec, I believe there was a barbecue named Barbie, where that was also conflicting with the brand of Mattel and their Barbies. So that was an issue about customer confusion, but it turned out that the two businesses were distinct enough. So that's kind of an example of customer confusion. So it has to be, like I said, distinct enough where businesses would not be confused. So again, if you need more information about that, we can, of course, look into it more for you as well.
Wonderful. We have another question here from Corinne. Does the Manitoba Legal Clinic for the Arts also serve digital artists, such as those working in video games, animation, or digital installations? And do they have to be unincorporated to be eligible?
Yeah, I can handle that. Thanks for the question, Corrine. I think without knowing the specificities of what you're looking to do, I think it's impossible to directly answer that. But I think what's best is if you could fill out a client intake form, and then we could decide and look at your particular issue. Regarding your second question, no, you do not have to be incorporated to be eligible for clinic help. Thanks.
Wonderful. Thank you, Robert. Okay, so that looks like all the questions we have. I'll just maybe toss it out there. Anyone else quickly want to toss something in? We could quickly answer it, but if not, just want to say thank you so much, Robert, Austin, and Scott. That was incredibly well explained, and thank you for that robust overview of some of the fundamentals. We appreciate that so much. Entrepreneurs tend to be a little bit scared, maybe scared or shy when it comes to legal matters, and this is just really helpful. So, and I see in the chat we're getting some thank yous from the crowd. So, one actually question, are the clinics only available to U of M students? Cool.
They are not. So we encourage anyone to fill out an intake form, and we'd be happy to talk to you.
Perfect. Okay, wonderful. And I believe that is everything. So just a final shout out to the Kerry Vickar Law Clinic. Thank you so much for joining us today. And just a reminder about future webinars, click the link in the chat and sign up for some other ones that you would like to see. And then just one last reminder is that you will get a copy of this recording in your inbox by today or tomorrow. So look for that if you want to reference anything they mentioned. And then again, we encourage you to check out the intake forms or the website they provided. So thanks again, Robert, Austin, Scott. And if I could clap or get the applause from the crowd right now, I would, but it's virtual. So thank you so much, and hope you just all have a great rest of the day. Oh, actually, Amy just said one more question in the Q&A. Tatiana wants to know, if someone wants to start a photography business, would you recommend to register as a corporation? I'm thinking photography business.
There's so many different considerations. It would be best if you would fill out an intake form, and then we'd be happy to meet with you and get some more information.
Perfect. Okay, that intake form is important. Well, then I'm going to